My dear students of the fourth year of law, English department, welcome to our fourth distance lecture. So as you know that we finished the first part of our program concerning conflict of laws, and we already started part 2 with international jurisdiction, and we talked about international jurisdiction, and we said that we have first of all we have the main principle, and we called this general principle actor sequitur forum rei. It is a Latin maxim. It means the competent court is the court of the defendant, and I told you that this is the general principle. So this is applied in domestic law and in private international law. It's the same principle, the same general rule, actor sequitur forum rei, which is the court of the defendant. Then we talked about the exception, and I told you when we talk about an exception, it means that we will not apply the general principle. We will apply the exception instead of the principle. This exception is concerning real estate matters. That means that when we have a case concerning a real estate in a country, the court of that country will be competent. So this is an exception to the general principle, which is the defendant, the court of the defendant. Then we talked about other specific fields which can be optional. So here we will talk about optional jurisdiction. That means that we will keep the principle applied, and we will offer the plaintiff other possibilities, so he can seize many courts. We have many choices, so he can choose one of these courts. So we will apply the general principle. So of course, if we don't talk about a real estate matter, if we talk about something else, we will have the general principle, and sometimes the legislator will add some optional jurisdiction concerning some specific cases. As I told you, for example, concerning as consumers, for example, or in torts, and sometimes in marriage. In these cases, we tend to protect the weak party, and as you know, in this case, the weak party will be the plaintiff, and we will try to give the plaintiff more than one option to make his jurisdiction or jurisdiction of the state competent on many other basics, of course, other than the general principle of the defendant domicile. For example, in torts, we have the Egyptian courts will be competent if the error or the damage occurred in Egypt. So in this case, the Egyptian courts will be competent. So this will be in addition to the general principle. That means that if the defendant, his domicile is not in Egypt, normally I should seize the court where the defendant has his domicile. But in this case, we have a weak party, so the person who got the damage can seize the Egyptian courts if the damage occurred, or the error or the wrong occurred in Egypt. So here I will offer him an optional case of jurisdiction. I will tell him, if the damage occurred in Egypt, you can seize the Egyptian courts. Of course, if he wants to seize the court of the domicile of the defendant, is also possible. So here we have he will have more than one possibility. And today we will talk about something else. It will come to complete this part, and we will talk about the subsidiary jurisdiction privilege, what I call subsidiary jurisdiction privilege. And this subsidiary jurisdiction privilege, sometimes we call it exorbitant jurisdiction or jurisdiction privilege. It's the same. We talk about the same point. What does the subsidiary jurisdiction privilege mean? As I told you, we have the general principle, and we have only one exception concerning real estate, and we talked about the optional possibilities. So in this case, the domestic courts can be competent not only if the defendant has his domicile in this country, but in some cases, to protect the weak parties, we can have more than one jurisdiction. So the question is, if the domestic court is not competent according to the first principle, the first general principle, nor the optional cases. In this case, the domestic courts will not be competent, of course, because we can't grant jurisdiction without a legal basis. So we should have an article. So as I told you, we have the general principle, and we have in some specific cases optional jurisdiction. So in this case, the Egyptian court could be competent if, for example, the damage occurred in Egypt, even if the defendant is domiciled abroad. So sometimes the defendant is domiciled abroad, and we can't build up jurisdiction according to the specific cases. So what can we do? The legislator added what we call, and what we will study today, subsidiary jurisdiction privilege or exorbitant jurisdiction. And this is why we study it after the two main rules. We have the general principle and the option. Now we will talk about the subsidiary. So it's a subsidiary, that means that it will come only after, if you can't grant jurisdiction to the domestic court according to the principle nor the specific cases. Concerning jurisdiction privilege or the exorbitant jurisdiction, is mainly built on nationality. What does it mean? It means that a state wants to protect its own citizens, and this will justify why a country will grant jurisdiction to nationals, okay, if there are plaintiffs or defendants, regardless their domicile, okay, because as I told you, first, the main principle concerning domicile of the defendant, whatever his nationality is. But the state, in some cases, any state wants to protect its own nationals. And this will explain why we have this subsidiary jurisdiction privilege. Because we will have to add more than one criteria. So here the criteria will be different. Let's take an example. So we have this in many countries. But just I want to mention that the jurisdiction privilege is a subsidiary way to offer nationals the opportunity to reach their national jurisdiction when it cannot establish its own competence according to the jurisdiction rule, what we have said before. So it only comes when we can't grant jurisdiction according to the principle, nor, as I told you, the other cases, specific cases. So the first example that we have, it was in the French Civil Code. So here we will go back to the Civil Code and not the procedure law. We will go back to the French Civil Code, and you can read, and you have it in the book, Article 14 and 15 of French Civil Code. It is the typical example of exorbitant jurisdiction. Let's read Article 15 first. Article 15 of the French Civil Code states that French persons, so here we talk about French persons, so French citizens, may be called before a court of France for obligations contracted by them in a foreign country, even with a foreigner. So, of course, we have a foreigner, so the other party will be a foreigner. Here we talk about a French person may be called, so here we talk about a French person who is the defendant. So, Article 15, we talk about a French citizen who is a defendant. And this French citizen is called, so he may be called before a court of France for obligations contracted by them in a foreign country, even with a foreigner. So that means that in all cases, we can seize the French courts if the defendant is French, even if his domicile is abroad. Even, for example, you can, as I told you this example last lecture, I told you that a French person who is, for example, domiciled in Egypt, you can seize the French court, even if he is domiciled in Egypt. Why? Because he is a French citizen. So he can, this French citizen, according to the French legal system, he could have the benefits of being seized in front of his domestic courts. So it will be the choice of the plaintiff, of course, the claimant. He will decide which court he will seize. But if he wants to seize the French courts, it's possible. Okay? Of course, as I told you concerning conflict of laws, we have to relate, of course, all the time. As you know that the plaintiff will find out which court will be competent, then he will choose the court that will offer him more advantage, or he will apply the best law for him. As I told you, this is the forum shopping. So he, in this case, he will find out which court could be competent, and he will seize one of those competent courts. So according to Article 15, a defendant, a French defendant, could be called before a French court. This is concerning Article 15. So here, Article 15, we have the case of a French defendant. Article 14. Concerning Article 14, I will read the article. A foreigner, even if not residing in France, may be cited before French courts for the performance of obligations contracted by him in France with a French person. He may be called before the courts of France for obligations contracted by him in a foreign country towards French persons. So here we talk about not French people, we talk about a foreigner. So we started with the foreigner. And we said that a foreigner, even if not residing in France, because as you know, here we talk about a French plaintiff. So here's the claimant is French. Article 15, the defendant was French. Article 14, here we talk about the French plaintiff. This is why we started with a foreigner. Here the foreigner is the defendant. So if he is not residing in France, because this is the principle is the foreigner should be domiciled or have a residency in some cases in France to make the French courts competent. So here we say, even if not residing in France, may be cited before French courts. But how? On which basis? For the performance of obligations contracted by him in France, so in France, with a French person. He may be called before French courts of France for obligations contracted by him in a foreign country towards French persons. So if the contract has been signed in France or abroad, but the main point is towards French persons, that means that the other party is French. And the other party is French, and the other party is this French will be the plaintiff in this case. So that means that it will offer the French person to seize French courts if he is a plaintiff and even if the defendant is not domiciled in France. Same principle, same cause. It is to give an advantage to the French citizen. So a French person doesn't have to go abroad to seize a foreign court, to seize it for an obligation contracted with a foreigner. So the French courts will still be competent. So as I told you, it is an option, it is a privilege for the French citizen. So this is let's say that's a gift from the state to its citizens to give jurisdiction to its own jurisdiction, so the national, the citizen can seize his own jurisdiction even if the foreigner, the domicile is abroad. This is concerning the French exorbitant jurisdiction. And now we will talk about how Brussels I regulation dealt with this kind of jurisdiction. Concerning Brussels I regulation, Brussels I regulation excluded domestic jurisdiction privilege. So how? Let's read Article 3 of Brussels I regulation. According to Article 3, the old article, Article 3, it says that persons domiciled in a member state may be sued in the courts of another member state only by virtue of the rules set out in sections 2 to 7 of this chapter. So sections 2 to 7 are concerning the general principles and the specific cases like consumers, like torts, etc. Then we talk about paragraph 2, in particular the rules of national jurisdiction set out in Annex 1 shall not be applicable as against them. According to this paragraph, the last paragraph, the Annex 1, the old Annex 1 mentioned many articles in all member states, so it will include Article 14 and 15. So if you check the old Annex 1, it will include Article 14 and 15 of the French Civil Code, because here we talk about the rules of national jurisdiction set out in this annex shall not be applicable against them. So the regulation wanted to put aside these articles. Why? For the same reason as renvoi, as we talked about when we talked about renvoi, is because we want to have harmonization of jurisdiction in European countries, and we can't have this harmonization with those rules, because in these cases all national jurisdiction will be competent for its own citizens, so the regulation will be kind of useless. This is why the regulation at first in Annex 1 contained all jurisdiction privilege articles of all countries. So when we talk about France, we have Article 14 and 15. Then the Brussels I regulation has been updated, and this Article 3 became Article 5, and it applies the same principle but in another form. So this is why the first version of Brussels I regulation was more explicit. This is why I put here the old article, Article 3, because it's more explicit. We say that we have an Annex 1. This Annex 1 will contain all articles which will not be applicable concerning international jurisdiction. And among those articles, we have Article 14 and 15 of French Civil Code, because those articles will grant jurisdiction only based on nationality. Then it changed, so it only the form changed, the article changed and became the Article 5, but this is not important for you. All what you need to know is that the Brussels 1 regulation excluded the domestic jurisdiction privilege. This is why I don't require from you, I only require the last two paragraphs of page 179. So I don't require page 180 and 181. يعني صفحة 180 و 181 مش مكررين عليكم، لأنه يعني هتكلم بقى يعني شوية كده باختصارا إنه إحنا هنا بنتكلم عن امتياز قضائي. زي ما قلنا إنه عندنا القاعدة العامة اللي هي موجودة سواء في القانون الوطني أو في قانون دولي خاص. القاعدة العامة هي إيه؟ هي موطن المحكمة المختصة، هي محكمة موطن المدعى عليه. ده المبدأ العام. وزي ما قلنا اتكلمنا عن الاستثناء اللي هو فيما يتعلق بالعقارات. طيب ده الاستثناء، فالاستثناء بيلغي القاعدة العامة، يعني بيطبق مكانها. ده فيما يتعلق بالقاعدة والاستثناء. بعد كده قلنا إنه في الحالات الأخرى غير العقارات عندنا قاعدة عامة، وفي بعض الحالات بيبقى عندنا اختصاص إضافي، يعني ممكن المدعي يختار أكتر من محكمة. ولما هو بيختار من أكتر من محكمة، سواء كانت بقى محكمة المدعي عليه اللي هو المبدأ العام، أو زي ما شفنا مثلا في بعض الأحيان المشرع بيبقى عايز يحمي بعض الفئات اللي هي في وجهة نظره هي طرف ضعيف، وبالتالي أنا مش عايز أرهقها في رفع الدعوة، فمش بقول لها كمان زي ما قلنا مثلا في موضوع المسؤولية التقصيرية مثلا، أو في المسؤولية بشكل عام، بنقول إنه الشخص هنا المضرور إحنا مش عايزينه كمان يتحمل عناء إن هو مثلا يسافر، أو إن هو يروح لدولة تانية، دولة المدعي اللي هي موطنه، ويرفع القضية هناك. فبنقول إن هو في هذه الحالة ممكن هو يرفع الدعوة فين؟ في مكان، لو كانت مصر هي مكان حدوث الخطأ أو الضرر، ممكن إن هو يرفع دعواه أمام المحاكم المصرية، بحيث إن إحنا برضو نديله فرصة إن هو يبقى عنده محكمة أخرى مختصة غير محكمة موطن المدعى عليه. وزي ما قلنا إنه محكمة موطن المدعى عليه هتكون مختصة وفقا لقانون هذه الدولة، مش وفقا للقانون المصري. برضو ما تنسوش الحتة دي، لأن دايما بفكركم إنه اختصاص أي محكمة بيكون وفقا لقانون الدولة، يعني الدولة نفسها هي اللي بتحدد اختصاص محاكمها. وبالتالي لما أقول محكمة موطن المدعى عليه بيكون وفقا لقانون هذه الدولة، مش وفقا للقانون المصري. فاحنا هنشوف هو في أغلبية القوانين بتكون المحكمة المختصة هي موطن المدعى عليه، يعني فدي قاعدة العامة. فمحكمة موطن المدعى عليه دي اللي هنروح لها. طيب لو المحكمة دي مش داخل مصر، فالقانون المصري بقى هنا في الحالة دي قال لو كان الضرر موجود في مصر يبقى عندك كمان اختصاص للمحاكم المصرية، وهو يقدر يختار من محكمة موطن المدعى عليه أو المحاكم المصرية لو كان الضرر في مصر. فيبقى هنا عندنا أكتر من محكمة مختصة، يبقى أنا أقدر أختار، أو كمدعي أقدر أختار ما بين المحكمة المصرية أو محكمة موطن المدعى عليه اللي هي في الخارج. طيب ده بالنسبة زي ما قلنا عندنا اختصاص كده يعني بيبقى يضاف إلى المبدأ العام. طيب عندنا دلوقتي بقى في الامتياز القضائي ده امتياز بيدي المشرع للمواطنين بتوع في الغالب بتكون المواطنين، بمعنى انه مثلا زي ما شفنا في القانون الفرنسي خلى المواطن الفرنسي سواء ان هو كان مدعي او مدعى عليه ان هو يكون امام المحاكم الفرنسيه، يعني بيخليه كده امام قاضي طبيعي، يقول له انت القاضي بتاعك القاضي الفرنسي، فاحنا هنوفر لك هذه الخدمه القضائيه. طب ازاي؟ سواء انت كنت مدعي، طب انت مدعي مش مدعي عليه، ومدعي عليه موطنه في الخارج، حتى لو انت مدعي لكن انت تحمل جنسيه فرنسيه يبقى تقدر تلجأ للمحاكم الفرنسيه. وفي العكس لو انت مدعي عليه ومقيم في الخارج، برضه من حق بقى المدعي اللي هو الاجنبي ان هو يلجأ للمحاكم الفرنسيه، باعتبار الشخص ده مش مقيم في فرنسا لكنه يحمل الجنسيه الفرنسيه، وبالتالي هو فرنسي يقدر ان هو المدعي ان هو يخليه يروح امام المحاكم الفرنسيه برضه باعتباره مدعي عليه في الحاله دي. يعني اللي هيلجأ للمحكمه الفرنسيه هيكون المدعي الاجنبي، بس مش عشان هو الفرنسي ده متوطن في فرنسا، لا هو متوطن في الخارج لكنه يحمل الجنسيه الفرنسيه، فده بيديله حمايه قضائيه، وبالتالي يقدر ان هو برضه يخليه يمثل أمام المحاكم الفرنسية. ده في الجزء المتعلق بالقاعدة دي. بعد كده اتكلمنا عن براسلز 1 ريجوليشن، وقلنا براسلز 1 ريجوليشن النسخة القديمة كانت واضحة جدا، كانت عاملة انكس، كانت عاملة ملحق. الملحق ده كان فيه أرقام المواد اللي هي بتستبعد. بعد كده الكلام ده اتطور فما بقتش واضحة شوية، لأنه بقى عملوا نظام، لأن بقى فيه تطور تشريعي، فعملوا نظام كده زي ان كل دولة هي اللي بتبلغ بالمواد اللي عندها. فعشان كده حاطط لكم نسخة الأصلية الأساسية اللي اتعملت قبل التعديل، وهي كانت أوضح جدا في هذه المسألة. يعني بتبين موقف المشرع الأوروبي من هذه القواعد. وزي ما قلنا نفس السبب اللي قلناه لما اتكلمنا عن الإحالة، وقلنا إنه برضو فكرة توحيد القواعد، إنه إحنا لو عملنا ريجوليشن هدفه إن إحنا نوحد قواعد الاختصاص. فلو قلنا إن كل محكمة هتبقى مختصة لمجرد إنه الشخص ده بيحمل جنسية هذه الدولة، فيبقى كده الهدف من اللائحة الأوروبية دي انعدم. فعشان كده استبعدت هذه القواعد. لكن زي ما قلنا ده في النطاق الأوروبي فقط. طيب هنشوف دلوقتي بقى موقف المشرع المصري، وهل في القانون المصري عندنا هذه القواعد ولا لأ، وبرضه موجودة في بعض الدول الأخرى. So now we will talk about Egyptian private international law. If we read the article 28 of Egyptian civil and commercial procedure law, we will find out that the Egyptian courts shall be competent to hear proceedings against Egyptians even if they do not have a domicile or a residence in Egypt. I will read it again. The Egyptian courts shall be competent to hear proceedings against Egyptians even if they do not have domicile or a residence in Egypt. نفس الكلام عندنا اهو. يبقى here in this case the Egyptian court will be competent to hear proceedings against Egyptians. So here we talk about Egyptian defendants. So in this case a foreigner can seize Egyptian court against an Egyptian defendant even if they do not have a domicile or residence in Egypt. Why? Because if he has a domicile in Egypt, in this case the Egyptian court will be competent according to the general principle. This is why the article mentioned this exception clearly, that if they do not have a domicile or a residence in Egypt. This is article 28. فاحنا عليه 28 المشرع المصري برضه عمل الكلام ده بالنسبة لي المدعى عليه المصري، ان هو المحاكم المصرية هتكون مختصة لو ان حتى لو كان لو القضية هنا مرفوعة على مصري against Egyptians even if they do not have a domicile or a residence in Egypt. يعني حتى هو بمجرد ان هو يحمل الجنسية المصرية بنقدر ان احنا وده طبعا بيوفر له الحماية. الهدف من الامتياز القضائي ده ان هو بنديله حماية. الدولة بتقول له انا بحميك كمحاكم بتاعتي، هي انت من حقك انك تلجأ لها او انك تمثل امامها في كل الاحيان، فده بيدي حماية اكتر او ضمانة اكتر للمواطن هذه الدولة. ده الهدف يعني من هذا النوع من الاختصاص. Let's check now article 32. Article 32 we have another kind of subsidiary jurisdiction privilege. The first one, article 28, it's a little bit like article 15 of French Civil Code. Here article 32 is different. I will read the article. The courts of the Arab Republic of Egypt shall have jurisdiction to adjudicate the case even if it is not within its jurisdiction, in accordance with the preceding articles, if the defendant or the opponent defendant accepts its mandate explicitly or implicitly. So what does it mean? That means that the Egyptian courts shall have jurisdiction the case even if it is not within its jurisdiction, of course according to the general principle and the specific cases. So if it is not competent in those cases, in accordance with the preceding articles, if the defendant accepts its mandate explicitly or implicitly. That means that in this case we talk about a case the plaintiff wants to seize the Egyptian courts. The Egyptian courts are not competent according to the general principles and the specific cases of Egyptian civil and commercial procedure law. According to those rules, the Egyptian courts are not competent, but the plaintiff wants to seize the Egyptian court, and the defendant accepts to be cited in front of the Egyptian court. So here we have both parties accepts the Egyptian court, but the problem here is that the Egyptian court itself is not competent. So what's the solution? That means that the parties، يعني هنا عندنا حالة ان عندنا الطرفين المدعي والمدعي عليه موافقين ان هم يلجأوا للقاضي المصري، لكن المشكلة ان القاضي المصري غير مختص وفقا زي ما قلنا القانون المصري، لان هو لا هو موطن المدعي عليه ولا هو حتى مكان مثلا حدوث الضرر او اي مسألة من المسائل اللي قلنا ايه المتعلقة بالاختصاص القضائي. وبحاجة من المصرية كده في الحالة دي تبقى غير مختصة، طب هنعمل ايه؟ فعشان كده عندنا بقى the article 32 will solve this problem. So that means that if we have a case in which the Egyptian courts are not competent, it will be competent according to article 32. What's the condition? The condition is, of course, first condition is normally the Egyptian courts should not be competent according to other articles, otherwise this article is useless. So first of all, the Egyptian courts are not competent according to general principle or the other articles concerning jurisdiction. And second condition is that the plaintiff, of course, he will seize the Egyptian court, and the defendant will accept this competence explicitly or implicitly. يعني هنا عندنا شرطين. طبعا أول شرط يكون إنه الاختصاص أصلا مش ممنوح للمحاكم المصرية، لأن لو كانت المحاكم المصرية مختصة وفقا لأي نص سابق يبقى خلاص يبقى تكون مختصة، يبقى ما عندناش مشكلة. لكن according to article 32 لازم تكون المحاكم ايه المصرية في الأساس غير مختصة. طيب ايه الشرط بقى عشان نطبق article 32 وتكون المحاكم المصرية مختصة؟ أول حاجة طبعا المدعي هيلجأ للقاضي المصري، ده رقم واحد. رقم اتنين يكون إنه المدعي عليه يوافق سواء بشكل صريح أو ضمني على هذا الاختصاص. طب ازاي؟ How he will accept the defendant the competence of the Egyptian courts. Explicitly he can, of course they can the parties can make an agreement. يعني زي كده مثلا شرط التحكيم او زي مشارطة التحكيم اللي بتتعمل، انه ممكن الاطراف هما يتفقوا في اتفاق مستقل انه المحاكم المصرية هتكون مختصة، او انا وافق كمدعي عليه ان انا امثل امام المحاكم المصرية. فممكن هنا يحصل اتفاق بشكل صريح ومكتوب وواضح، او بشكل ضمني. طب بشكل ضمني ازاي؟ how can the defendant accept implicitly? Implicitly normally he will just be cited, he will go in front of the Egyptian court. هو القبول الضمني بمعنى ان هو هيبقى ضمنيا ازاي؟ ان هو هيمثل امام القاضي المصري وهيتكلم في الموضوع. طالما اتكلم في موضوع الدعوة ودخل في موضوع الدعوة امام القاضي المصري، ده ضمنيا معناه ان هو قابل باختصاص القاضي المصري. هو قابل باختصاص القاضي المصري هنا بقى وفقا للماده كام؟ ماده 32، مش للقواعد الثانيه، لان زي ما قلنا القواعد الثانيه مش هتديله اختصاص. الماده 32 هتديله اختصاص في الحاله دي. يعني عندنا الطرفين عايزين يروحوا للقاضي المصري، فهنا بيدي اختصاص هنا بقى ايه؟ يونيفرسال جوريسديكشن، بيدي اختصاص عالمي للمحاكم المصريه. لان القاضي المصري انا لو عايز الجا له، سواء بقى حتى لو كان القاضي المصري غير مختص والطرفين موافقين ان هم يلجأوا للقاضي المصري، هيلجأوا ليه وفقا لنص هذه الماده. بس زي ما قلنا بشرط موافقه المدعي عليه، سواء صراحه ان هو يكون في اي اتفاق صريح على هذا الامر، ان هو يكون عبر عن موافقته دي بشكل صريح، او بشكل ضمني عن طريق مثوله امام القاضي المصري، وان هو على طول بيقدم دفاع في الموضوع الدعوه. وبالتالي في هذه الحاله طالما دخل في الموضوع الدعوه يبقى كده هو قابل بايه؟ باختصاص المحاكم المصريه بشكل ضمني، ان هو قابل بشكل ضمني ان هو مثل امام المحكمه. ده فيما يتعلق بايه؟ بايجيبشن jurisdiction privilege. يبقى احنا عندنا حاجتين، عندنا article 28 concerning Egyptian defendants، وعندنا article 32. Let's check now another country which is Germany. In Germany we have article 23 of the Code of Civil Procedure of Germany, we have where the defendant is not domiciled in Germany, the same case, so that no other German court has jurisdiction. Actions relating to property instituted against a person who is not domiciled in the national territory come under the jurisdiction of the court of the place where the property or subject of the dispute is situated. So what does that mean? That means that according to German Code of Civil Procedure, here the criteria is different. Here we didn't build the jurisdiction privilege on nationality like we did before. Of course, in Egyptian law, in French law, it is only based on nationality. In French law, we have two articles. The first one is based on nationality. The second one is based about freedom of choice. So in Egypt, we have two articles. The first one is based on nationality, like in French law, and the second one is based on freedom of choice. If the both parties accept to go in front of the Egyptian court, it will be competent. In German law, it's a bit different, because here we talk about another criteria. This criteria is the lex situs, or the situation. So here we talk about the person, so the defendant is not domiciled in the national territory, so the German courts will not normally be competent. So in this case, according to Article 23 of German Code of Civil Procedure, if we talk about a property or subject of the dispute is situated, so here we talk about the place of the property. If the dispute is concerning a property and this property is situated in Germany, the German court will be competent. Okay, so here the criteria is the situation, the property situation. So the German courts will have jurisdiction over any defendant who owns assets in Germany, regardless of their value and regardless the domicile of this owner. Let's have an example. A Chinese man, so a Chinese tourist, he will go in Berlin. He will take a room in a hotel in Berlin, and he has a camera, and this camera is very heavy. And this man forgot his camera in a place, and this camera fall down and broke the glass or broke the floor. So the hotel can sue this Chinese man. Of course, he's a tourist, so he will go back to his home, to China. So the hotel can sue this Chinese man. Normally, it will the Chinese courts should be competent in this case. Why? Because it is the defendant court. But according to this article, the German hotel can sue this Chinese man in Berlin for an enormous amount concerning a case that has no connectivity with that camera at all. Why? Because when he forgot the camera inside the hotel, it made a specific harm, for example, to the hotel itself. And in this case, the hotel can seize this Chinese man in front of the German courts. Why? Because here the property was situated, the property which caused the harm is situated in Germany. So he forgot it. So he went home and he forgot the camera. And in this case, the German courts will be competent only because the property was situated in the German hotel in Germany. So if we have a dispute concerning a property and this property is situated in Germany, the German courts will be competent. So here the criteria is not based on nationality like Egypt and France. It is based on the property situation. Let's now find out the situation in the United States. In the United States, we have a third criteria. So here we talked about, so far we talked about the French law, and the French law is based on nationality. Egyptian law is based on nationality and freedom of choice. German law is based on property situation, and United States, we will find out which will be the criteria. We have a case in United States called Bryant versus Finnish National Airlines. Bryant versus Finnish National Airlines. The facts are that a resident of New York sued the defendant for injuries. Of course, the defendant is Finnish National Airlines, which normally is domiciled in Finland. It's a Finnish airline company. And the plaintiff was a resident of New York, and he got injuries in Paris. He seized the courts of New York. So this passenger, he was injured, as I told you, in Paris airport because a baggage cart injured him. And the passenger brought an action in New York, and the Finnish airline company brought a motion to dismiss the complaint. Why? Because of lack of personal jurisdiction. There is no jurisdiction. And the Court of Appeal said that the Finnish company was doing business in New York. Thus, we can seize the defendant in front of New York court. Why? Because the foreign company is doing business in New York. Even if it was a room in New York airport, and it is not a big headquarter, for example, or a big office, but it will still doing business in New York. So once the company is doing business in New York, the New York courts could be competent. This is the solution of this case. We have another case. It's called Frommer versus Hilton Hotels International and Corporation. So what happened? We have a Hilton hotel in United Kingdom. So we have an American citizen visited England in 1963, and he got injured inside of London Hilton Hotel. This injured person will seize American courts against Hilton Hotels to repair the damage. Same as the last case, it is concerning doing business. So this is the criteria of American law. So the London Hilton Hotel alleged that the court is not competent. Why? Because it's not the defendant's domicile, because the defendant's domicile were supposed to be in London. But according to the civil practice law rules, so we have in the book CPLR 302, this is civil practice law rules. Those are the civil rules of New York, so in America. in the United States, we have that, of course, you know that the court can exercise personal jurisdiction over a foreign corporation if it transacts any business within the state. What we call the criteria of doing business. So when we talk about the cause of action, and remember what we have said concerning torts in conflict of laws, we said we have to find out the cause of action. Here we said that the cause of action were arising from the transaction of such business. So here the cause of action will be the company if it was doing business in the United States of America. So as you know, Hilton hotels are in the United States. So we have some Hilton hotels in America. So Hilton hotels is doing business in America also. So once the company is doing business in the United States of America, the American courts will be competent, even if the facts are related to another hotel in another country. But once this company, the same company, is doing business in the United States, the United States courts will be competent. This is the basic of the jurisdiction privilege. So here the jurisdiction privilege is based on doing business. Once a company is doing business in America, the American courts will be competent. This is concerning. So if we go back to what we have said today, we say that the French law is based on nationality, Egyptian law is based on nationality and freedom of choice, German law is based on the situation of the property, and finally the American law is based on doing business. It means that where if the company is doing business in America, the American courts will be competent. So this is all for today, and next lecture we will continue our program. And as you know, that next lecture will be a distance lecture too. So see you next week, but don't forget that we have a distance lecture. Normally it will be on Thursday. See you later. Goodbye.